At the conclusion of this lecture, you will be able to distinguish between sole traders, partnerships, and companies. You will understand the meaning and effect of limited liability. You will analyze different types of companies, illustrate the effect of separate personality and the veil of incorporation, and recognize instances where separate personality will be ignored. A sole trader describes any business that is owned and controlled by one person, although they may employ workers, for example, a bakery. Individuals who provide a specialist service, like hairdressers, plumbers, or photographers, are also sole traders. Sole traders do not have a separate legal existence from their owner. As a result, the owners are personally liable for the firm's debts and may have to pay them out of their own pocket. This is called unlimited liability. The advantages of a sole trader are: the firms are usually small and easy to set up. Generally, only a small amount of capital needs to be invested, which reduces the initial startup cost. The wage bill will usually be low because there are few or no employees. It is easier to keep overall control because the owner has a hands-on approach to running the business and can make decisions without consulting anyone else. The disadvantages of a sole trader are: the sole trader has no one to share the responsibility of running the business with. A good hairdresser, for example, may not be very good at handling the accounts. Sole traders often work long hours and find it difficult to take holidays or time off if they are ill. Developing the business is also limited by the amount of capital personally available. There is also the risk of unlimited liability, where the sole trader can be forced to sell personal assets to cover any business debts. We have already examined partnerships in the previous presentation, and we will now examine the types of companies. Section 3 of the Companies Act 2006 sets out the various types of companies which can be registered in terms of different liabilities. Companies can be formed without liability. These, by virtue of Section 3, Part 4 of the Companies Act, are referred to as unlimited companies. Such companies are incorporated under the Companies Acts and receive all the benefits which flow from incorporation except limited liability. Therefore, the shareholders in such unlimited companies remain liable to the full extent of their personal wealth for any unpaid debt of the company. It should be noted that in line with the doctrine of separate personality, even in the case of unlimited companies, any subsequent debt is owed to the company and not directly to the creditors of the company. The compensating benefit enjoyed by such companies is that they do not have to submit their accounts and make them available for public inspection. The company limited by guarantee is found under Section 3, Part 3 of the Companies Act and is restricted to private companies of a non-trading kind, such as charities or professional and educational bodies. It limits the members' liability to an agreed amount, which is only called on if the company cannot pay its debts on being wound up. In reality, the sum guaranteed is usually a nominal sum, so no real risk is involved on the part of the guarantor. The more common procedure is to limit liability by reference to shares, which is covered in Section 3 of the Companies Act. The effect of this is to limit liability to the amount remaining unpaid on shares held. If the shareholder has paid the full nominal value of shares to the company, then that is the end of responsibility with regard to company debts. Consequently, if the company should subsequently go into insolvent liquidation, the shareholders cannot be required to contribute to its assets in order to pay off its outstanding debts. Both public limited company, PLC, and private limited company, LTD, can be formed. As shareholders in limited companies have the significant protection of limited liability, the courts have always seen it as the duty of the law to ensure that this privilege is not abused at the expense of the company's creditors. To that end, they developed the doctrine of capital maintenance, the specific rules of which are now given expression in the Companies Act of 2006. Section 3 of the Companies Act sets out the various types of companies that can be registered in term of different liabilities. In the previous presentation, we discussed unlimited liability in detail and limited liability briefly. Now we will examine limited liability in detail. A type of liability that does not exceed the amount invested in a limited partnership or limited liability company. The limited liability feature is one of the biggest advantages of investing in publicly listed companies. While a shareholder can participate wholly in the growth of a company, his or her liability is restricted to the amount of the investment in the company, even if it subsequently goes bankrupt and racks up millions or billions in liabilities. In a limited partnership, the limited partners have limited liability, while the general partner has unlimited liability. The limited liability feature protects the investors' or partners' personal assets from the risk of being seized to satisfy creditor claims in the event of the company's or partnership's insolvency. The principle of separate corporate personality has been firmly established in the common law since the decision in the case of Solomon v. Solomon and Company Limited, whereby a corporation has a separate legal personality, rights, and obligations totally distinct from those of its shareholders. Legislation and courts, nevertheless, sometimes pierce the corporate veil so as to hold the shareholders personally liable for the liabilities of the corporation. Courts may also lift the corporate veil in the conflict of laws in order to determine who actually controls the corporation, and thus to ascertain the corporation's true contacts and closest and most real connection. Upon incorporation, the company becomes a new and independent legal entity. It is completely separate from the subscribers who formed it and from those who manage it. A company can sue in its own name, and creditors can generally only sue the company, not its members, to recover damages. The company can own property and assets in its own name as well. In the leading case of Solomon v. Solomon and Company Limited, Solomon incorporated his business and subsequently changed it to form a company. He took all the shares of the company except 6, which were held by his wife, daughter, and 4 sons. Part of the payment for the transfer of the business was made with a secured loan issued by the company of Solomon. Solomon transferred the debentures to Broderick in exchange for a loan. Solomon defaulted on payment of interest on the loan, and Broderick sought to enforce the security against the company. Unsecured creditors tried to put the company into liquidation. It was argued for the unsecured creditors that Solomon's security was void, not legally binding, as the company was a sham and in reality the agent of Solomon. However, the House of Lords held that the company had been properly incorporated, and therefore the security was valid and could be enforced. Lord Macnaghten stated that the company is at law a different person altogether from the subscribers to the memorandum, and although it may be that after incorporation the business is precisely the same as it was before, and the same persons are managers, and the same hands receive the profits, the company is not in law the agent of the subscribers or trustee for them. Once it was acknowledged that a company enjoyed a separate and legal existence apart from its members, another consideration needed to be dealt with, namely the rights of creditors. The fact that many companies were incorporated with limited liability further highlighted the notion that creditors' rights were limited. If creditors dealt with this separate legal entity in which members had limited liability, then any recourse which they may have had would be to the company itself. Thus, the separate legal entity doctrine was a two-edged sword. On the one side, the rights of members were limited, and on the other side, a creditor's practical ability to seek redress was also limited. In order to balance this, the courts can pierce the veil of incorporation under certain circumstances where the courts will deny the people who run the company the advantage of hiding behind the corporate veil. In these instances, the veil of incorporation is said to be pierced or lifted, i.e., the barrier between a company and its members is removed, so there is no legal separation between them. These instances are difficult to predict, as the reasons depend on the judge's interpretation of fairness or policy, or of how a particular statute should be interpreted. There are numerous circumstances where the veil will be lifted by the courts, and they include, but are not limited to, agency, fraud, group enterprises, trusts, enemy, tax, the Companies Act itself. We will now examine some common law reasons for lifting the veil. Agency. In some circumstances, a company may act as an agent for others, for example, shipping agents or investment brokers. Moreover, it is possible for a company to act as the agent for its own shareholders. This may be done by express contract or impliedly. In the case of Briggs v. James Hardy and Company Limited, Briggs suffered from a medical condition allegedly caused by negligence of his employer. His employer was a subsidiary of the defendant. In an action against both his employer and its holding company, one argument which had to be addressed was whether the corporate veil could be lifted so as to find the holding company liable. The New South Wales Court of Appeal admitted to the possibility of the veil being lifted and remitted the case back for determination. Fraudulent use of the corporate form. Lord Halsbury, in Salomon's case, acknowledged that the corporate veil will not protect a fraudulent person hiding behind the corporate structure. Illustrative of this is the decision in Guildford Motors Company Limited v. Horn. Similarly, in Jones v. Lipman, Lipman agreed to sell land to Jones. Before completion of the contract, Lipman transferred the land to a company of which he and a clerk employed by his solicitors were the only shareholders and directors. Jones brought an action for specific performance of the contract against both Lipman and the company. The court held that the company was a sham and ordered specific performance of the contract. Groups of companies. Companies may form part of a group of companies where, for example, they operate with a holding company and subsidiaries. On occasion, courts will regard the entities as one. In conclusion, while a sole trader is easy to set up, it has unlimited liability. There are a variety of ways to set up a company. Companies formed without liability, companies limited by guarantee, and companies limited by shares. Limited liability protects the personal assets of shareholders. The separate legal entity was established under Salomon v. Salomon. Courts and statute will lift the veil where it deems fit.